Hey guys, welcome to this video. The question is, when do you object to improper questions or affidavits or other evidence in an Alabama debt collection trial? And I realized when somebody left a comment that I have not addressed this. And so in this video, I want to address it. And I'll talk a little bit about what you object to, or at least what we object to if we're doing this. And then at the end, I'll mention we're going to do a longer series or longer video that will also cover some of this. So the basic concept is whenever the invalid testimony or evidence is offered by the debt collector. So you wouldn't normally object before any evidence is offered. In other words, to say, well, Judge, if they offer any of the following, I object to it. Now, in sort of bigger trials, when we're in what's called circuit court or federal district court, where we have juries, we do things called motions in limine, which in essence is objecting ahead of time. But if you're doing a debt collection trial in Alabama where you've been sued by a debt buyer, 99% of the time you're going to be in small claims or district court in Alabama. So judges there are not particularly interested in getting a, quote, motion in limine. Okay, so it's whenever that evidence is brought forward. So the question is asked, the affidavit is offered, the documents are offered, that's when you would object. And so in testimony, it could be that the collection lawyer flies in a witness from Midland or Portfolio or whoever it is, and they could be asking their own witness questions. And I really can't tell you how to object to that. I mean, you may gather a little bit from this video, but that's really beyond the scope of this video. What's more likely is the collection lawyers asking you questions, trying to prove that you owe the debt and that they own the debt through your testimony. So it would be when they ask you questions. And I've mentioned this in other videos, and I can't remember as I am doing this video now if it's 1,000 or 10,000, but you'll get the concept. Supposedly Bruce Lee said, I do not fear the man that's practiced 1,000 kicks, or it could be 10,000 kicks, once, but instead I fear the man that's practiced one kick 1,000 times. And the idea is sometimes people, when they're going into court, they try to learn everything. Well, it's kind of hard to learn everything if you haven't been to law school and you haven't been doing this for many years. And so what happens is sometimes people sort of have half knowledge about a bunch of different things, and none of that works. Instead, if I have somebody that has come to me and said, hey, I want you to help get me ready for trial so I can do this on my own, I would say, let's have you focus on one or two things, know those really, really well. And it's not going to protect you if something comes out of left field, but for the majority of the time, it'll be the best approach. So the easiest type of objection is lack of personal knowledge and also hearsay. And so lack of personal knowledge is saying, Judge, the witness is being asked something that they could not possibly know. Now, if you're representing yourself, it may seem a little strange to say, Judge, I object to lack of personal knowledge. And I wouldn't recommend doing that very often. You could just say, I don't know. But sometimes the lawyer will ask you a question like, tell me all the facts that you know of that prove we do not own the debt. Well, the simple answer to that is, I don't know. But what I would suggest if I was doing it, if I was representing myself, is I would say, well, Judge, first of all, I think that's an improper question. He's asking me to prove something I have no idea about. I don't know what they do in their secret, deals and transactions. I haven't seen any of the evidence of it. And so there's no way I could know this. And for most judges in Alabama, maybe all judges in Alabama, I think they would get the point. Go, okay, yeah, he's asking something you don't really know. Or they might say, tell us the details of the transaction between Synchrony Bank and Portfolio Recovery. Well, how would you possibly know that? So again, that's a way to object. And just keeping that in mind, like you're testifying under oath, you are swearing or affirming that what you're saying is true. Well, if you have no idea, certainly don't answer it and say yes or no if you have no idea. Instead, answer truthfully, but you might also point out to a judge, this is something I could not possibly know. And then hearsay is asking you about conversations or documents created outside of court that are being offered to prove the truth of the matter asserted. And we'll talk about this in other videos. I don't want to make this one too long. But the idea is that they're saying, well, look at this letter from, the original creditor to us, the debt buyer. Doesn't that prove it? Like, well, I don't know. That's hearsay, because that wasn't created in court. Now, there are some exceptions to hearsay, and there are exceptions to exception. We're not getting into all that. But just understand, hearsay is really any conversation outside of court. Now, again, there are times when they can offer those because they meet an exception, but that is something that you can do when they're asking you something. You're like, I don't know what this is. Say, well, Judge, there's no way I could know this. And it seems like that would be hearsay also. And so that can be an approach. Now, written evidence, again, same concept. You object when the evidence is offered. Now, the most common type of evidence that will be offered in small claims or district court is an affidavit. Affidavit is a sworn statement. And almost always it will be by an employee, maybe directly, or an employee of a related company to the debt buyer, the debt collector that has sued you. In other words, the plaintiff. And what I would do, first of all, is make sure you realize what court you're in. If you're in district court, if you object, the judge is not to allow any affidavit because you can't cross-examine an affidavit. It's a piece of paper. Now, in small claims court, the judge can allow this. But in my experience, even though they have that option, usually if you object and say, Judge, this is an affidavit, I can't cross-examine a piece of paper, they should have brought a real witness here. Usually the judges will say, yeah, we're not going to do affidavits. But even if they do, just study that affidavit very carefully to see what are the problems. So the person signing the affidavit, do they work for the plaintiff? We have seen a bunch of affidavits where, let's say it's XYZ debt collector suing you, and the person offering the affidavit says, well, I work for XYZ Roman numeral 4 debt collector. And you go, well, that's not the same one that sued me. And a lot of times the lawyer go, oh, well, that's just a typo. Or Judge, we have so many of these related companies. I mean, it's hard to keep them straight, but they're all basically the same thing. And a lot of judges will say, well, you need to get that straight if you're coming into my court, because somebody that works for XYZ debt collector Roman numeral 4 can't testify to what XYZ debt collector does. So that's something to look at. Do they have personal knowledge? So they say, well, I know what happened. Well, how do they know what happened? Usually they'll say, well, we studied the business records, or we studied this or that. But sometimes they don't. Sometimes they'll say, based on information and belief. Well, what does that mean? That means they're guessing. So do they have personal knowledge? And here's where a lot of times it really comes to a head. Is this person who's offered the affidavit, are they testifying to procedures at the original creditor? In other words, they say, I know how Chase Bank maintains its business records for credit cards. I know how they maintain their statements, how they process payments, how they calculate interest, late fees, over the limit fees. I understand all of that. Well, how? How do they understand that? Do they work at Chase currently? Did they spend 20 years working at Chase and they left 2 months ago? I mean, we had one where they brought a live witness and the person testified to that. Said, oh, I know that their record-keeping process is very accurate, very thorough. So how do you know that? Now, normally when you're cross-examining somebody, you don't ask an open-ended question, but here we knew that the answer would help us. We said, how do you know that? He said, well, I have a Chase card, and when I get my monthly statements, they look accurate to me, so therefore they have great record keeping. And it's like the judge is kind of burying his head in his hands, like, we start to object. He's like, no, you don't even need to object. Okay, so think about that. Are the collection lawyers saying, hey, Judge, Susie Smith, who worked for Midland, she testified that Chase Bank keeps accurate records. Well, again, I would object to that. How does she know that? Lack of personal knowledge, hearsay. And then this is probably the most important point with affidavits is, does the affidavit prove the ownership of the debt? So remember, this debt collector claims that they bought the debt. And we've talked about this in dozens of videos. There's a big difference in claiming to own the debt and actually proving you own the debt. I can say I'm the President of the United States of America. It might not be true. Okay? People can claim all sorts of stuff that's not true. They have to prove it. So the affidavit likely will say, we own the debt. Okay? Well, how do you own the debt? They'll say, well, we have a bill of sale attached, and that's a one-page document. We're going to go over some of these in a detailed video where I'll put them up on the screen. But the bill of sale is just a small piece of the purchase agreement. The purchase agreement is where they actually buy this $100 million of debt for $5 million or whatever it is. Do they attach a purchase agreement? And the answer is almost always no. Well, without attaching that purchase agreement, how does this Susie Smith, who's offering the affidavit, how does she know that they bought the debt? She would have to have that purchase agreement. And normally the affidavit will not say that she reviewed the purchase agreement. They don't let the people doing the affidavits look at these things. They keep these top secret. Well, if she hasn't looked at it, certainly she hasn't attached it. And even if she says, oh, I looked at it, well, there's a general principle with affidavits. Whatever documents you rely on in an affidavit should be attached to the affidavit so that the court and the other side can see, well, what's the basis of your opinion here, of your testimony by affidavit? Because remember, you can't cross-examine an affidavit, a piece of paper. So they really have to put all their evidence there. And it's extremely rare to ever see a purchase agreement with one of these affidavits. And again, we'll talk about this in another video, but the bill of sale will almost always refer to the purchase agreement and say, hey, if you want to look at the limitations, the terms, the conditions of the purchase of these debts, look at the purchase agreement. And that will almost never be there. So that can be something very helpful when you're attacking one of these affidavits. And a number of years ago, for our own clients, we created a book, 7 Mistakes Consumers Often Make When Testifying in Debt Collection Trials. And I think we have that up on our website now. We need to go in and update it. But I'll do a video where I go through each one of those. And that's really designed for if you are testifying, and especially if you're doing this on your own, if you do not have a lawyer. And this is based on Alabama. I don't practice in other courts. If you're in another state, there's some of this that may apply, but you also have to understand your own rules. So anyway, we'll get to that. That's on my list, and hopefully I'll get to that soon. But I hope that this is helpful to you, and I appreciate you watching this video, and hopefully this answers the question. I realize it's a little bit long, but the basic idea is you object when the bad stuff, the invalid stuff, the evidence, the testimony that violates the rules of evidence, whenever that is being offered. You say, Your Honor, I object to that because of, and then you say whether it's lack of personal knowledge or hearsay or whatever the rule of evidence that you are objecting based on. So thanks for watching this, and I'll catch you in the next one. Thanks. Bye.